Hi, Disha, we are
Yeah.
to go. We can start the program at the count of five.
Okay. Good evening, everyone. Welcome to SEED's second Dr. Ambedkar Memorial Lecture. We would like to thank LiveLaw for hosting this second lecture in the annual lecture series. I am Disha Vadekar. I am an independent practicing advocate before the Supreme Court, and I'm the co-founder of SEED. I also have along with me SEED's co-founders, Anurag Bhaskar and Avinash Matthews. Anurag is an assistant professor at Jindal Global Law School. Avinash is an advocate at the Supreme Court. We also have with us our team member Hamsa Dwani, who is a law student and a SEED fellow. Um, we, of course, have with us our very esteemed guest speaker for the day, Dr. Justice S. Murlidhar, Honorable Chief Justice, High Court of Orissa. We at SEED hold an annual lecture series on Dr. Babasaheb Ambedkar's birth anniversary to celebrate his legacy and stir conversations around the issues of law, marginalization, and representation within the legal fraternity. Last year, on the same day, we had invited Dr. Justice D.Y. Chandrachud, and he spoke to us about, he spoke on the topic why representation matters. Today's topic is appearing in court, challenges in representing the marginalized. And this topic is especially relevant and important for two reasons. Uh, we are gathered here and we are, celebrating Dr. Ambedkar's birth anniversary. And as we all know, he's the architect and the chief architect of the Constitution, and he has donned many roles, one of which was that of a practicing lawyer who advocated for the marginalized. One of the most landmark cases, and he has fought many landmark cases, but one of the most landmark cases, and my own personal favorite, is that of the defamation suit of Jedhe and Zavarkar at the Pune District Court. And this case is at the very core and at the heart of the discourse on free speech and expression. Um, the other reason why today's lecture is really important and especially relevant is because our esteemed guest, Honorable Chief Justice Murlidhar, who is here with us, will be speaking to us about this topic, and he'll be sharing his views and his experiences with us from the bar. So he himself has, been a practicing advocate, and he's practiced before various courts, including the Delhi High Court. And it will be really interesting and enriching lecture, I'm sure. So I will hand it over now to Anurag. Anurag will briefly introduce SEED and the work that we have done in the past 1 year through SEED. Anurag?
Yeah, thanks, Disha, and hello, everyone. So, as Disha mentioned, we started SEED as an initiative last year, and SEED stands for Community for the Eradication of Discrimination in Education and Employment. So, SEED is a network of lawyers, law firms, judges, and other organizations and individuals who are committed to reform the Indian legal profession and judiciary. Been engaging with the like reforming the profession in three ways. First of all, as our flagship program, we help students from these communities to get paid internships in the profession, and in there, our impaneled network of lawyers, law firms, and judges provide one paid internship to each student selected by us every year. We shortlist students after a long, comprehensive application process, and then we allot them to the lawyers, law firms, judges, and other individuals who have empaneled with us. So, apart from that, we also have been doing capacity building program for students from marginalized communities. From time to time, we have focused even on basic things such as how to arrange your CV, how to write applications or emails, and other soft skills that students may not be having, students from marginalized. So we are helping them through capacity building programs. And thirdly, we are doing research and advocacy on the issue of increasing representation of marginalized communities, the profession, and the judiciary. So till now, in last 1 year, through SEED, we have arranged 86 paid internships. We have had more than 7 capacity building programs and sessions over the year. We have 95 advocates, law firms, and lawyers and NGOs who have impaneled with us till now. And more than 300 students from marginalized communities have registered with us, to whom we can constantly guide and mentor. And finally, we are also helping students to get LLM admissions abroad. That we have been able to help 2 students to get admissions abroad in this year. So that's a bit about SEED's work. Now I'll request my colleague, Vani, who's a student at Nuals Kochi and a fellow at SEED, to take from me and invite Justice Muralidhar.
SEED. We're honored to be joined by Dr. Justice S. Muralidhar today, and I'm even more honored to be introducing him. Dr. Justice S. Muralidhar is the Chief Justice of the High Court of Odisha. Prior to this, Justice Muralidhar served as a judge at the Delhi High Court from 2006 to 2020. Subsequently, he served as a judge at the Punjab and Haryana High Court. Dr. Justice S. Muralidhar began his law practice in Chennai in September 1984 and later shifted his practice to the Delhi High Court and the Supreme Court. He was also active as a lawyer for the Supreme Court Legal Services Committee and later was its member for 2 terms. He was appointed amicus curiae by the Supreme Court in several public interest litigation cases and in cases involving convicts on death row. Justice Muralidhar was also counsel for the National Human Rights Commission and the Election Commission of India and was also a part-time member of the Law Commission from December 2002 till May 2006. As a judge, Justice Muralidhar has authored several important judgments such as Rajendra Grover versus Air India Limited, which dealt with gender discrimination in service conditions of cabin crew, and Kulvinder versus State and City of Delhi, where the High Court set aside the trial court verdict and held that the Mirchpur Dalit killing incident of 2010 was an instance of caste-based violence. He was also part of the division bench in Sudama Singh versus Government of Delhi, which dealt with the resettlement of the Jhaggi inhabitants, and in Naz Foundation versus NCT of Delhi, which held that Section 377 of the IPC, insofar as it criminalizes consensual sexual acts of adults in private, is violative of Articles 21, 14, and 15 of the Constitution, and several other such judgments. We are so honored once again to have you here, sir, and we now invite Dr. Justice S. Muralidhar to speak.
Good evening, Avinash, Disha, Anurag, Hamsadwani, and Vinod, who's managing backstage. It is a privilege to be invited to speak on the occasion of the birth anniversary of Dr. Ambedkar and the completion of 1 year of the launching of Community for Eradication of Discrimination in Education and Employment, SEED. A year ago, 3 young lawyers, Anurag Bhaskar, Disha Wadekar, Avinash Matthews, came together to launch the self-empowering initiative SEED, which provides opportunities in education and employment to those belonging to the marginalized communities in India, with special focus on Dalits, Adivasis, other backward classes, indigenous communities. One of the laudable objectives of SEED is to increase the representation of the marginalized communities in the legal profession in India. It is the last mentioned endeavor that has prompted the choice of the topic for today's lecture. The many years of active practice as a litigator provided me with an opportunity to study the legal services delivery system from close quarters. Being a lawyer on the panel of the Supreme Court Legal Services Committee for close to 15 years, a member of the committee for 2 terms, and an amicus curiae in a number of cases involving public interest and human rights, helped me understand the complexities of the issues that require to be addressed while discussing the theme of access to justice. representing many of the marginalized groups in court made me ponder over questions for which there were no easy answers then. I doubt it is easier now, although the complexities of the issues is better acknowledged in the empirical and research work done in the past few years on the working of the Indian legal system. One such study is the report published in October 2021 by the American Bar Association Center for Human Rights on Dalit justice defenders in India. I will have occasion to refer to it later in this talk. I seek to briefly set out what I propose to speak on. In the first part of the talk, I wish to add to our understanding of whom we consider to be a person in need of legal services, and in that context, whom we understand to be a marginalized person. Next, I wish to focus on the barriers that a marginalized person encounters in the legal system and how the system has responded to the problem. I ask, can we really understand what it means to be a marginalized person facing the barriers in the system? Third, and this is an important part of the talk, the challenges faced by those who seek to represent the marginalized or espouse their causes. The final part of the talk will dwell on how we should be approaching the challenges thrown up in the process of representing the marginalized. At a very basic level, every person denied justice in the broadest sense of the term and who has to perforce engage with the legal system for redressal is in need of legal services. The Indian Constitution acknowledges persons who by birth, descent, caste and class have been denied justice over generations. It envisages the state coming up with affirmative action programs and policies to redress such historic injustices. These include those belonging to the scheduled castes, the scheduled tribes, Dalits, Adivasis, socially and educationally disadvantaged classes, economically deprived classes, and a whole host of others, including religious minorities, sexual minorities, differently abled, children in conflict with the law. Then there are status offenders like sex workers, vagrants, mentally ill, and many others whose very existence and every activity is criminalized and therefore very often find themselves on the wrong side of the law. Thus, begging, street dwelling, prostitution, wandering of mentally ill persons and vagrants are all treated as law and order problems and dealt with in the criminal justice system. It is a matter of concern that in at least 20 states in India, there are still anti-beggary laws. Only in Delhi and Jammu and Kashmir have the anti-beggary laws been struck down by judicial verdicts. Then there are the denotified tribes who have for long been the victims of police atrocities. Those coming in conflict with the law in these situations are invariably those below the poverty line and a high-risk group for whom legal aid is an absolute necessity. They are to be acknowledged as unwitting consumers of legal services. There is also the problem of excluding certain categories of persons from the ambit of legal services. Early legal aid schemes statutorily sought to disqualify those arraigned in cases involving offenses under the law prohibiting prostitution or child abuse and the like, and those involving economic offenses from receiving legal aid. Under Article 22, subclause B of the Constitution of India, the right available to every person who is arrested to consult and be defended by a legal practitioner of his choice is not available to a person who is arrested or detained under any law providing for preventive detention. Consistent with this bar, Section 11, subsection 4 of the National Security Act, Section 8, Clause E of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act bar the right of a détenu to legal representation in proceedings before the advisory board, which examines the need for continuing the detention. This, to some extent, has been addressed by Section 12 of the Legal Services Authorities Act, in terms of which every person who is in custody is entitled to legal aid. No exception is made for cases in which custody is by way of preventive detention. And yet, under Section 13 of the same enactment, a legal aid functionary could refuse legal services in a criminal case on the ground that no prima facie case exists. Then we have the pernicious prospect of a bar association resolving that no member lawyer will defend a certain kind of accused, a person accused of committing what is termed a terrorist act. This despite the fact that the Supreme Court has outlawed it. The Indian criminal justice system provides for those willing to see a stark depiction of the intersection of law and poverty. Professor Upendra Bakshi states that the words poverty and poor suggest the passivity of the poor. He says, and I quote, "Everything about the poor and poverty is defined in terms of a lack. Powerlessness, apathy, disorganization, alienation, and anomie are some of the major attributes we use to define and describe the poor. This cluster of attributes," he says, define what he calls the culture of poverty, which is a culture of multiple disabilities and lacks transmitted across generations. Noted scholar Barbara Harris White prefers the term destitution and its myriad forms to describe what those in poverty experience. Professor White describes economic destitution as having nothing, social destitution as being nothing, and political and law-induced destitution as having no rights and being wrong, each of which results in denial of personhood or full citizenship. While tabling the final draft of the Indian Constitution before the Constituent Assembly on 25th November 1949, Dr. Ambedkar reminded everyone, and I quote, "On the social plane, we have in India a society based on the principle of graded inequality. We have a society in which there are some who have immense wealth as against many who live in abject poverty. That scenario continues to plague Indian society even 7 decades thereafter. Dr. Ambedkar was also prophetic that despite independence, we could not call ourselves truly democratic unless we ensured social democracy. He was not sanguine about this. He prophesied that, and I again quote, "In our social and economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one value. We are yet to dismantle the structures that marginalize a sizable section of our population. Thus, we still have amongst us those engaged in manual scavenging, sewer cleaning, rack picking, and those engaged in forced labor or begar, doing all our dirty work at the cost of their dignity and right to life. And then, poverty need not be understood only in economic terms. As the Allen Committee that was commissioned by Robert Kennedy, the then Attorney General in the 1960s in the USA, to study poverty and the criminal justice system observed, poverty is also a functional incapacity to obtain in adequate measure the representation and services required by issues whenever and wherever they appear. Let me explain. A married woman belonging to the higher or middle income group who is a victim of domestic violence and finding herself incarcerated in her marital home in an upper class neighborhood may still be deprived of legal services. The definition of marginalized, it would seem, is thus not as simple as one might want it to believe it to be. It is thus entirely possible that a person in India, on account of a social or economic disadvantage, is denied legal services. We may be creating a set of social and economic outcasts through law. I move on to the next part of my talk. The marginalized enter the legal system in a variety of ways, very often involuntarily. They come in as victims of crime, crimes against humanity, mass crimes, hate crimes, caste and communal crimes and atrocities. They come in as witnesses to crimes and atrocities. They come in as complainants. They come in as victims of forcible evictions, of neglect, of poverty, of natural and man-made disasters, of human conflicts, including caste and communal riots. And of course, they come in as persons suspected of committing crimes. 21% of the under trial population of 3.72 lakhs in this country and 21% of the convict population of 1.13 lakhs belong to the scheduled caste. 37.1% of the convicts, 34.3% of the under trials belong to the OBCs. The corresponding percentages for Muslims, 17.4% and 19.5% respectively. And yet, these are the persons who are likely to find it difficult to come forward to fight for their rights. Again, to quote Dr. Ambedkar, "Ask those who are unemployed whether what are called fundamental rights are of any value to them. If a person who is unemployed is offered a choice between a job of some sort, with some sort of wages, with no fixed hours of labor, and with an interdict on joining a union, and the exercise of his right to freedom of speech, association, religion, etc., can there be any doubt as to what his choice will be? How can it be otherwise? The fear of starvation, the fear of losing a house, the fear of losing savings, if any, the fear of being compelled to take children away from school, the fear of having to be a burden on public charity, the fear of having to be burned or buried at public cost are factors too strong to permit a man to stand out for his fundamental rights. The unemployed are thus compelled to relinquish their fundamental rights for the sake of securing the privilege to work and to subsist. I end the quotation. The formal legal system in India is a legacy of the British legal system. For many a marginalized person, navigating the formal legal system is a nightmare. Law professor Stephen Wexler, in a fairly accurate description, says, poverty creates an abrasive interface with society. Poor people are always bumping into sharp legal things. There are many barriers to accessing justice that a marginalized person faces. The laws, rules, and processes are mystifying and befuddling, even for an educated, literate person. The laws are themselves structured to discriminate against the poor. Specific examples are the anti-beggary laws that criminalize poverty, the Immoral Traffic Prevention Act that criminalizes sex work, the juvenile justice law that delivers the street child into the arms of the law, and even the municipal laws that criminalize acts of encroachment of public spaces by street-dwelling homeless persons and hawkers. The system works differently for the poor. The beggars' courts, the juvenile justice boards, the Mahila magistrate courts are often the first points of encounter for the poor with the legal system. A visit to any of them in a metropolis in India will bear out the truism that the system works unequally for the poor and the rich. Many under trials continue to remain in jail despite grant of bail because of their inability to arrange surety bonds. For long, sexual minorities and trans persons have had to live in fear of the criminal law processes. Even after Section 377 of the Indian Penal Code was read down, first by the Delhi High Court in Nas Foundation, and later by the Supreme Court in Navtej Johar, and even after the declaratory judgment of the Supreme Court in National Legal Services Authority's case, NALSA, in 2014, affirming the full citizenship and personhood of trans persons, it is a struggle on the ground for sexual minorities to cope with their daily lives. The changes, it seems, are happening with all deliberate speed, a phrase that translates as very gradually. I will have an occasion later in this talk to explain this more. To tackle the inequality and iniquity of the formal legal system, we have institutionalized the delivery of legal services through the Legal Services Authorities Act. We have a 4-tier mechanism with the National Legal Services Authority, the State Legal Services Authority, the District Legal Services Authorities, and the Taluka committees. We also have the Legal Services Committees for every High Court. We have attempted, through this entire institutionalized mechanism, in providing not just legal representation, but legal services as well. And this is both at the pre-litigation and post-litigation stages. We have schemes that are meant to provide a complainant, a victim, and a suspect legal assistance at every stage of the criminal justice process. And yet, as Justice Uday Lalit, Executive Chairperson of NALSA, noted recently, and I quote, only 1% of the total criminal cases heard in the courts of law get legal aid from the offices of the legal services authorities across the country. He identified 2 reasons. 1, lack of awareness, and 2, more disturbingly, he said, and I quote, they don't perhaps have confidence in the setup of legal aid, unquote. The fact remains that the quality of legal aid is a concern. The marginalized who are recipients of legal services do not really have a choice. This is a paradox because Article 22 of the Constitution of India talks of guaranteeing a person arrested with a lawyer of her choice. In the Constituent Assembly, while debating the wording of Article 15 capital A, which was later to be Article 22 in the final draft, Dr. Ambedkar adverted to the suggestions made in regard to the right of an accused person to consult a legal practitioner. With a view to removing the ambiguity, he said, and I quote, I am prepared to add after the words consult, the words and be defended by a legal practitioner, so that there would be the right to consult and also the right to be defended. He also explained that the words legal practitioner of his choice had been deliberately used, and I quote, "Because we do not want the government of the day to foist upon an accused a counsel whom the government may think fit to appear in his case, because the accused persons may not have confidence in him," unquote. This lack of confidence in the legal aid lawyer is a reflection of the general approach to welfare services by the providers and the perception that this is an act of charity rather than the right of the person in receipt of such services. It impinges on the dignity of the person. I call it the ration shop syndrome. The poor believe that if you are getting any service or benefit for free or it is substantially subsidized, then you cannot demand quality. Beggars can't be choosers is the stoic response that keeps the poor going. In a critical study of the public defender system in the USA, Charles Silberman found that defendants who were represented by legal aid lawyers said, "He is not my lawyer, he is the legal aid." And that in the court, when judges ask who the lawyer is in the case at hand, legal aid lawyers typically answer, "I'm standing up for this case, not I'm representing this client, let alone I'm representing Mr. Jones." The laws and legal system also appear to work differently for the marginalized. Recently, a Supreme Court bench of Justice D.Y. Chandrachud and Justice B.V. Nagaratna noted that several members of the scheduled caste, scheduled tribe communities face insurmountable hurdles in accessing justice from the stage of filing the complaint to the conclusion of the trial, and that they specifically suffer on account of procedural lapses in the criminal justice system. The press report of the hearing quoted the bench as saying that due to fear of retribution from members of upper caste groups, ignorance, or police apathy, many SC/ST victims do not register complaints in the first place. And even if they do, the victims and witnesses are vulnerable to intimidation, violence, and social and economic boycott. The bench is reported to have noted that, and I quote, "This results in low conviction rates under the SC/ST Act, giving rise to the erroneous perception that cases registered under the Act are false and that it is being misused. On the contrary, the reality is that many acquittals are as a result of improper investigation and prosecution of crime, leading to insufficient evidence." Close quote. Indeed, the statistics put out by the National Crime Records Bureau on the conviction rates in SC/ST cases bear out these remarks. In 2020, the pendency of trials for offenses under the SC and ST Act was 96.5%. Only 216 cases from the 50,291 crimes against SCs in 2020 resulted in convictions. 3,192 cases resulted in acquittals. The above scenario is equally true in cases of communal riots and mass crimes. Where the trial is able to be insulated from the local pressures, there's a greater chance of reaching the goal of justice. Illustratively, these would include the cases of burning of Dalit households in Mirchpur village in Haryana, where the trial was shifted to Delhi, or mass killings of Muslims in Hashimpura in Uttar Pradesh by the Provincial Armed Constabulary. Again, the trial was shifted to Delhi. Or the case of rape and murder of a Bakarwal girl in Kathua in Jammu. The trial was shifted to Pathankot. Or the Gujarat riot cases, the Best Bakery and the Bilkis Banu cases, both of which were shifted to Maharashtra. In each of these instances, the trial itself had to be transferred to different states since there was no assured witness protection program for the marginalized, who became soft targets for intimidation. Then within the formal legal system, there are problems posed by hidden and other costs that have to be inevitably borne by the recipients of legal aid. Here I have the unedifying task of quoting my own work, Law, Poverty and Legal Aid, Access to Criminal Justice. And I quote, "One disincentive for a person to avail of legal aid offered is the problem of uncompensated costs that have to be incurred. Legal aid schemes do not account for the hidden costs incurred by those brought involuntarily into the system, either as victims or as accused. While the legal aid program may pay for court fees, cost of legal representation, obtaining certified copies and the like, it usually does not account for the bribes paid to the court staff, the extra fees to the legal aid lawyer, the cost of transport to the court, the bribes paid to the policeman for obtaining documents, copies of depositions and the like, or to prison officials for small favors. Legal aid beneficiaries do not get services for free after all. At the end of a long litigation, where the person emerges innocent, he is not awarded the cost of litigation. Thus, the amount of time and money spent on establishing innocence remains unrecoverable and non-compensable. Equally, it is a loss to the victim of the crime and to the taxpayer whose money has gone into funding the entire prosecution exercise. Close quotes. Law professor Deborah Rhodes, in her piece titled "Whatever Happened to Access to Justice," has this to say, and I quote, "Not all barriers to justice are in the judicial system. Some are part of a larger problem of economic disadvantage. Many factors affect the justness of the legal process apart from the adequacy of legal assistance. The substance of legal rights and remedies, the structure of legal processes, the attitudes of judges and court personnel, and the resources, expertise, and incentives of the parties. On almost all of these dimensions, as law professor Mark Galanter famously put it, the haves come out ahead." Close quotation. Studies abroad have shown, and this is true to a large extent in India as well, that there is a parallel system involving the police and the mafia that derives benefits from the activities of criminalizing prostitution, beggary, and other activities of the marginalized. There exists a system of prepaid legal services for those involved in organized crime rackets and other criminalized activities. Professional criminals are able to engage lawyers and obtain bail for those made to beg by them. They're also able to arrange sureties and professional bonds. In the context of sex work, the recent Sanjay Leela Bhansali film, Gangubai Kathiawadi, starring Alia Bhatt, focuses its lens on the nexus between brothel owners, the political class, and the police. This is a vicious quagmire that the marginalized are unable to liberate themselves from. Are the alternate dispute resolution ADR systems within the formal legal systems a solution to the problems of the marginalized? As they presently stand, the options of mediation and arbitration do not seem to be available to the poorest among the litigants, particularly since they find themselves ensnared in the criminal justice processes or face forced evictions, homelessness, displacement, and a myriad issues in confronting the state. They, however, do feature regularly and largely in Lok Adalats with their claims for either motor vehicle or land acquisition compensation and are asked to settle for less, as it were. Legal scholars Mark Galanter and Jayant Krishnan term this phenomenon as bread for the poor. The marginalized also feature in jail adalats, where they have the Hobson's choice of longer periods of incarceration as opposed to admitting to guilt in petty offenses for a premature release, but with the tag of a previous conviction. There does not appear to be any dignified space rendering complete justice to the marginalized litigant in the ADR space as yet. That may be an area that needs further exploration. Non-formal systems are perhaps the first choice for the rural and urban poor, deterred as they are by the prospect of having to engage with the formal system. But here again, while the caste panchayats might offer solution to some civil disputes, it is doubtful that they are truly representative institutions when it comes to some of the critical issues concerning the marginalized, particularly when it comes to the cases of crimes against women, caste-based discrimination and violence, cases of intercaste runaway couples. The track record of the informal systems has not been encouraging. For the marginalized, traversing the legal system, whether formal, alternative, or non-formal, is a daunting task full of uncertainties and perils. I move now to the third part, where I begin to explore what representing the marginalized in courts entails. That takes me to understanding how the bar is organized. I ask, is the bar democratic? Is it a place of equal opportunity? Is it diverse? Or does it mirror to a large extent the social and economic inequalities that are ubiquitous in Indian society and home to the biases that plague social life? The study on India's grand advocates by Mark Galanter and Nick Robinson is fairly well known in legal circles. These two legal scholars have stated that, despite repeated inquiries, they could not identify any scheduled caste, scheduled tribe, and other backward class advocates who are regarded as part of the elite strata of lawyers. I suspect that the legal service institutions may not be faring any better. Do we know how many of the legal aid panels are advocates? Advocates are Dalits? what percentage of the arbitrators, mediators, counselors, conciliators do they constitute? The study I referred to begin with on Dalit justice defenders in India makes an important contribution to our understanding of the lack of diversity in the bar. After conducting interviews with lawyers, former and current judges, academics, and others, the study concludes that in the high courts, and I quote, the bar is dominated by lawyers of upper castes and well-to-do families with a network of connections. Close quote. Some of the respondents admitted that in lower courts, caste plays a role in getting clients. One of the conclusions drawn from the interviews conducted was that the structure of the legal profession is based on the ability of an individual to secure references, resources, and have a network, all of which are difficult in an environment with caste discrimination. The study also reveals very tellingly that bar associations have historically been dominated by upper-class males. The lawyers belonging to the marginalized have experienced indirect discrimination, being asked to perform relatively unskilled tasks in law offices. There is also a tendency to typecast lawyers from Dalit and other marginal groups. A woman lawyer who described herself as the first-generation Bahujan lawyer without any caste networks or financial support found the journey to be a lonely experience and found the attitude of senior counsel as patronizing and loaded with notions of charity. She was treated as a token or diversity candidate and importantly stated that the dignity of being a colleague was missing. The study found that lawyers belonging to Dalit and Adivasi communities working on human rights cases risk being labeled as Maoist or Naxalite lawyers. The same study mentions a positive development that has taken place in the form of the National Dalit Movement for Justice, NDMJ, which has brought Dalit and Adivasi advocates together on a platform for intervening in Dalit atrocity cases in courts. The NDMJ claims to have trained 2,000 lawyers across the country so far. I am aware that the Center for Social Justice in Ahmedabad too has done considerable work in this area. These are not one-off initiatives. Several individual lawyers and smaller groups and organizations are confronting these challenges on a daily basis. However, all of this is not yet enough. The legal profession, as it is presently structured, does not necessarily provide a level playing field to all those entering into the system in various capacities. As a litigant, as a suspect in a criminal case, as a victim of crime, as a person denied justice, as a witness and an accused, as a lawyer, and even as a judge. The legal profession, to a large extent, mirrors the inequalities and the biases of the society. The cab rank rule by which the legal profession purportedly operates does not work for those who cannot afford cabs in the first place. The marginalized, to use a rough analogy, traverse the legal system by foot or other overcrowded buses or trains, very often at personal risk to their life and safety. The luxurious sedan that charges a higher tariff is largely out of reach, even when infrequently they do get a token joyride. Occasionally, you will have a top-notch senior lawyer do a case or two completely pro bono and with positive outcomes. But for most other cases in the Indian subordinate courts, where the marginalized largely meet their destiny with choiceless stoicism, the informal rules by which the bar functions are dictated largely by a supply and demand situation, where competent lawyers are in short supply and therefore they are in great demand. In almost every rung of the structured hierarchy of the legal profession, more than 80% of the work is controlled by less than 20% of the lawyers, who are usually referred to as the active practitioners of any bar. These active practitioners would have their own class and caste biases in how they approach cases, in how they prioritize their work, and how they treat their clients. More than a century ago, Gandhiji commented that in India, the law courts are perhaps the most extravagantly run. He noted, and I quote, "Several thousand rupees had been known to be charged in India. There is something sinful in a system under which it is possible for a lawyer to earn from 50,000 to 1 lakh per month." And this is more than a century ago. The legal practice is not and ought not to be a speculative business, says Gandhiji. The best legal minds must be available to the poorest at reasonable rates. In a documentary titled All Rise for Your Honor, and this was a documentary that was invariably screened for all the new trainees in the National Judicial Academy in Bhopal when Professor Mohan Gopal was its director. In that documentary, All Rise for Your Honor, the director Sumit Khanna depicts the plight of an elderly rural woman trying to get an affidavit that she needs in a civil dispute signed by her son, who's lodged in a jail in Varanasi. Even with the help of the filmmaker and all of this on camera, a sum of 1,500 rupees has to be spent just on getting the affidavit attested by a notary magistrate who travels with them to the jail to get the affidavit signed by the prisoner in his presence. All of this only to be told later that it was not necessary at all. It is a very telling commentary on the way the legal system in the courts is plagued by ignorance of laws and procedures among lawyers, which works to the disadvantage of those already marginalized. Self-representation, that is the litigant appearing in person, is not really an effective alternative. They often face the seemingly insurmountable barriers of legalese and court etiquette, which are tools of persuasion cultivated by the bar over the years. On a lighter note, in an episode involving an elderly litigant appearing in person in court during abstention of work by the bar, the judges interrupt the elderly gentleman's submissions by saying, "Babuji, आप जो कह रहे हैं, हम समझ नहीं पा रहे हैं. आप वकील रख लो." To which the elderly litigant responds, "कमाल है, समझ आपको नहीं आ रही है और वकील मुझे रखना है." But occasionally, you do have the type of dedicated and conscientious lawyer that we saw Nasiruddin Shah play in Govind Nilari's Akrosh, Rajkumar Rao play in Hansal Mehta's Shahid, and Southern Star Surya play Chandru in Yanavel's Jai Bhim. The lawyers in those stories are the ones that we must get the young entrants to the bar have as role models. And among the younger generation of lawyers that I see in courts, I do come across one or two that have that potential. Such lawyers at present are a small number and in great demand. They too are stretched beyond their resources, and at times this dilutes their efficacy. Unfortunately, there is a tendency of late to view appearing for the marginalized as making a political choice. These decisions have the potential of marginalizing those representing the marginalized. They are not the high-flying, ambitious, career-oriented lawyers. They plug away at cases, knowing that the system is weighted against their clients. Gandhiji was one such lawyer who in South Africa appeared for marginalized clients in large numbers, knowing fully well that the system was weighted against them and against him. The lawyer Vinay Vora, played by actor Vivek Gombar in the Marathi film Court by Chaitanya Tamahane, is one such. Yet, some of them who stand up for unpopular causes that don't meet the approval of the dominant voices in society face stiff resistance. They face threat to their lives, boycotts and expulsions by the bar associations, and even unwanted intrusions by law enforcement agencies. However, their presence in court does lend legitimacy to the legal system, which is essential for upholding the rule of law. There are also the civil society groups that have, for many years, been working with the marginalized, with the homeless, the sex workers, the children in conflict with the law, the slum dwellers, the rack pickers, persons employed in manual scavenging and sewer cleaning, helping them organize, question state and police excesses, demand protection and enforcement of rights. There are also the paralegal workers that help the marginalized avoid or exit institutionalization by their interventions. The system needs all of them for its legitimacy. The marginalized need them for their survival. A larger and less intimidating space has to be provided for these non-state players in the system. Finally, I come to the question, how do we enable the marginalized to meet the challenges? First, we need to acknowledge that the marginalized largely view the legal system as irrelevant to them as a tool of empowerment and survival. Their experience tells them that it operates to oppress, and they have to devise ways of avoiding it rather than engage with it. Without fundamental systemic changes that enable erasing to some extent this negative perception of the legal system and the legal profession in particular, mere changes in the system of legal services delivery by themselves may not enthuse greater engagement with the system, however promising the results may seem. It is bound to be viewed with suspicion. To begin with, we need to revive the discussions around decriminalizing many of the survival activities of the poor, including payment dwelling, encroachment, hawking, begging, sex work. We have to act more on legal institutional reforms. For instance, finding alternate, less coercive ways of running Nari Niketans, observation homes for boys and girls, beggars' homes, instead of modeling them on the penal custodial institutions. Professor Deborah Rhodes highlights for us the kind of questions we might want to ask in our approach to reforming the legal services delivery system. And I quote, "Should individuals be entitled to assistance on all matters where fundamental rights are at issue, or only where their claims seem meritorious? When should they receive lawyers' help? And when would other forms of aid be sufficient? How should legal aid providers allocate assistance between individual representation and collective impact work, such as lobbying, organizing, and test case litigation? And most important, how should those decisions be made?" Test case litigation can be an effective tool for bringing about systemic changes. There are lessons to be learned from the manner in which the civil rights movement in the USA went about litigating the issues of discrimination. Professor Charles Ogletree, his seminal work titled All Deliberate Speed, describes in detail how the early work of test case pioneer, Professor Charles Hamilton Houston, for the NAACP, that is the National Association for Advancement of Colored People, to seek parity in payment to white and black teachers in public schools. That paved way for the later litigators like Thurgood Marshall, who went on to become a judge of the Supreme Court of the USA, to bring forth simultaneously in a range of courts spread across the states cases concerning segregation in public transport, public facilities, universities, schools, and so on. Brown versus Board of Education did not happen overnight. In fact, it comprised 5 cases, all of which were treated as a batch, and Brown versus Board of Education was the lead case. It was a culmination of many years of struggle and perseverance with conviction and painstaking fact gathering for presentation in the court. Basically, a lot of hard work. And then there has been a constant struggle to get the tangible results of such test litigation realized in the succeeding years without diluting the verdict in Brown versus Board of Education. The follow-up order in Brown that the US Supreme Court handed down in September 1955, 1 year after Brown, basically permitted the consequential changes of desegregation to be only gradually carried out. It used the phrase "with all deliberate speed," basically meaning that you can do it gradually. The book of Ogletree explains what a struggle it has been to actually get Brown versus Board of Education implemented, and that struggle continues even today. The NALSA judgment of the Supreme Court of India that recognizes full citizenship and personhood of transgenders is another such test litigation that is yet to witness the tangible effects on the ground. Professor Ogletree himself spent a large part of his early professional life honing his lawyering skills with the Public Defender Service in Washington, D.C. He emphasizes that if any system of public defender has to be effective, there can be no compromise on the quality of professional competence of its lawyers. In more contemporary times, the pro bono work of lawyer Brian Stevenson in the US, devoting his energies to getting innocent black convicts released from death row, is inspiring. In his book, Just Mercy, Brian tells us how a conscientious lawyer handling cases of the marginalized needs to be emotionally and mentally strong, politically aware, professionally competent, and be prepared to take on a hostile system with calm and fortitude. We need many Ogletrees, we need many Brian Stevensons in India. How do we improve the quality of legal services here in India? To begin with, we need to attract the better, if not the best available legal talent for legal services. Since fees is such an important incentive for a lawyer to take up a case, it is necessary to ensure that the fees paid to the Legal Aid Council representing indigent accused in criminal trials involving grave offenses is the same as is paid to the prosecutor. The fact is that there is no scarcity of financial resources with legal services authorities. It is the distribution of the resources that needs paying attention to. Even if it is a salaried system, when you deal with less serious offenses, even if it's a salaried system, the salary to the legal aid lawyer must be commensurate with what the lawyers would usually and reasonably charge private clients. Here, we cannot pick the high end of the tariff, but the mean, to ensure that the legal aid lawyer does not lose out for taking up a legal aid case. To expect senior lawyers to take up cases as pro bono would not be doing justice to the clients. They would always be made conscious that they are recipients of charity or beneficial treatment, which does not respect their dignity or be able to demand accountability from counsel. For trials involving complex issues and tasks, the services of a combination of a senior and junior lawyer should be able to be offered. If I recollect, the Supreme Court Legal Services Committee had come up with such a scheme where, in cases involving grave offenses, a senior and a junior combination of lawyers would be engaged by the Supreme Court Legal Services Committee. Secondly, and importantly, we need to ask, how do we orient the lawyer to take up the cases of the marginalized? How do we get the lawyer to understand what it means to be a marginalized person having to navigate an intimidating and alienating legal system? Can we get the lawyer to truly understand how the marginalized person feels and thinks? How do we ensure that the legal aid lawyer is thoroughly professional in understanding all the nuances of the law and is able to match the opponent in terms of its competence? The legal aid lawyer would do well to remain aware that legal aid is not charity. It is the basic right of the marginalized. The consumers of legal services must be consulted at every stage of the case. They should be patiently listened to. They cannot be made to lose control over their case. They must have a say over the course of action or strategy to adopt. If pleadings are in English, and invariably they are, and the client cannot understand that language, it has to be read over and explained in the language that they understand. Offering services pro bono or at state expense does not entitle the lawyer to make concessions and statements in court that do not correctly reflect the client's position or ends up in compromising their position. It could be a political position, it could be a position on facts. At all times, the persons for whom one is representing must be kept in the loop and informed about everything that is happening in court. Nothing must be done in the court without their consent. Also, there can be no room for cynicism. If the system appears broken, we are part of it, and we need to do our bit to fix it. When the marginalized still have hopes of the system, lawyers who care can hardly afford to give up hope. Lastly, to increase representation of the underprivileged and marginalized in the legal profession, one has to begin early. One has to begin with law colleges. Initiatives like increasing diversity by increasing awareness, IDIA, the brainchild of late Professor Shavnath Bashir, is indeed welcome. The presence of the underprivileged in law colleges is by itself not enough. They need to be handheld through the law course and thereafter till they are placed with seasoned lawyers or law firms. Bar council and bar associations need to emulate the IDIA model on a larger scale. There has to be mentoring of young lawyers belonging to the marginalized groups with the more seasoned lawyers. The Bar Council of India can float a scheme offering stipends for a limited number of years to promising young lawyers to help them find their feet in the profession. There is much to be done, and it needs to be done now. We have the resources, we must find the will. I've come to the end of my talk, but before I end, I would like Vinod to play a video that I've sent him.
Let us leave aside slogans. Let us leave aside words which frighten people. Let us even make concession to the prejudices of our opponents. Bring them in so that they may willingly join with us on marching upon that road which, as I said, if we walk long enough, must necessarily lead us to unity. This is too big a question to be reduced to the position of mere legality. It is not a legal question. I say leave aside all these considerations and make some attempt whereby those who are not prepared to come will come. Let us make it possible for them to come.
Thank you very much.
Avinash, you're muted.
Avinash, you're muted.
Thank you, Justice Muralidhar. I thought that was an excellent talk. I thought you adumbrated the challenges in representing the marginalized extremely well. A quick question, since you are seen as a technological maverick, so say, what we realize as young lawyers is that often quality representation starts with quality tools and access to the law itself, tools like Manupatra and SCC. And what we've seen with SEED is that a lot of law schools don't even have the budget to be able to provide their students training in these software, which becomes so crucial to like quality representation. Is there something that, is it that we've reached a stage where even providing that sort of research capacity is the role of the court or the role of the state, for actual quality representation to happen? And is that something that the court can take up? Because we have Indian Qanun, which is a very powerful public resource, and some good people have put their minds to it, but it can only take you so far. What do you suggest in terms of just access to legal tools, legal research in order to improve, quality of representation?
Avinash, the answer is quite simple. All law colleges function with the sanction or clearance of the Bar Council of India. The Bar Council of India is to simply add another conditionality to its approval or recognition of law colleges, that a law college library will have these minimum journals, and that could include all these online journals. From the Odisha's experience, I can state with some degree of satisfaction that only last month we provided to every district bar association, the High Court provided an e-library which had two of the journals that you mentioned. We had AIR Online and Manupatra, and we've also given them one local law journal. We've given them a room in every bar association. We've even given it in outlying stations, 2 outlying stations, and I'm hoping in a couple of months, all outlying stations in Odisha will also have it. So I've given it to the bar because the young lawyers in the bar associations do need these tools. But I completely accept your plea. And I think the Bar Council of India should be able to find an easy solution to this. We don't need the courts to come in for this also.
Fair enough. And hopefully they'll move in that direction. So I'd like to point out that the report that you had cited is actually co-drafted by, yes, that report is co-drafted by Anurag, one of my co-founders. Okay. And hopefully we can do more research and representation, because there's a severe dearth in a good research and articles on this topic, and hopefully SEED can do that.
If I can just come in for a minute, now that you mentioned it, you remember I showed you this book, Professor Ogletree's? Yes. And I mentioned how Ogletree was part of the Public Defender Service in Washington, D.C. And one of the questions they asked was, is the Public Defender Service truly representative? They found that there were not enough black lawyers in the Public Defender Service. So your research might take you further into questioning how representative many of our legal services delivery systems are.
Yeah, and that's what we're trying to do at SEED. We're trying to get lawyers into these places so that there is representation, and so that the marginalized are comfortable with the legal system and aren't scared of it. I think there's this pervasive fear of the legal system, and that's not what it should be. Starting from police stations, people are scared to go to police stations. And, I think...
I can tell you the fear is all pervasive.
Yes, which is quite depressing.
In a sense.
So I'll just wrap up then.
Yeah, I think it's about putting your heads together and finding the will. Because despite everything that we find going wrong, we still find there is space for those conscientious people who keep fighting and who keep finding, the space for these issues. And that's whom we should look up to, and that is what we need to expand, develop on. Look at the case of Bryan Stevenson. Yeah, he's still against a whole system of prejudice, right? But they just keep going at it. And I think we should do that.
Yeah, and hopefully instead of the exception, that becomes the norm, and that is what, the standards are in our society and in our justice system. I'll just wrap up. Yeah,
Avinash, with every generation, and I can say this confidently after being a judge, with every generation of lawyers, and now I've seen about 3 generations of lawyers. In the newer generations, there are always those younger minds that are idealistic, willing to work, fired with conviction. That gives me hope. It gives my colleagues hope, and I don't look at it obliquely at all.
Yes.
Look at the 3 of you. What a wonderful initiative this is, right?
Yeah.
I'm sure you'll be inspiring other younger law students, like Hamsadwani, for instance. Yes.
Yeah. Thank you for the kind words. It means a lot, and we do this along with our other work, and so words like this really help us, carry on and push through. I'd like to thank you for coming here and spending your time and giving us extremely detailed lecture. I think everyone who's watching has learned a lot, and we do hope that we as SEED can interact with you again in the future and work together. Thank you, Live Law, for helping us with the logistics, and it's an excellent system that you have, and it all went off without a hitch. So thank you, Vinod, as well. At this point, I'd like to thank Hamsadwani, who is our fellow, and without whom a lot of the work at SEED could not be possible. She does the everyday stuff that Disha, Anurag, and I cannot do, but she does it very responsibly, despite the fact that she's in law school and she has plenty of other responsibilities as well. And she has an extremely bright future ahead of her. I'd like to thank the empaneled lawyers, the lawyers who have been empaneled with SEED, because it's them who are putting their necks out and taking in our students. They really help out. Some really encouraging stories from the past 2 cohorts. We had a student come up to us and tell us about the wonderful experience they had with a lawyer who made special arrangements in his chamber so the student could offer his namaz. And at the end of the internship, he gave him a constitutional law commentary and encouraged him to return. We have another story where a senior advocate, on hearing that a law student couldn't make it for the internship in the city, paid the stipend in advance and ensured that that student had lunch with the senior advocate every day of the internship so that they felt comfortable. So we are extremely thankful to our empaneled lawyers who go above and beyond, and we hope that any more lawyers who are watching will empanel. Please visit our website for that. And we couldn't survive without our patrons and donors who help us fund our initiative. This time we're offering scholarships for students, needy students from rural areas, to be able to have physical internships, because that makes all the difference. Actually being in a court, being with the lawyer, seeing the little things that they do. And a lot of people just don't have this opportunity. Even logistically, it's a very challenging thing. So if you would like to donate towards these students and this cohort, you can go to www.seed.co.in/donate. And we would really appreciate that. And you will be helping someone. Thank you again, Justice Muralidhar, for an enlightening evening. And yeah.
Yes. Thank you, sir.
Bye.
Thank you, sir. Thanks.
Thank you, sir. Thank you so much for coming.
Thank you.
Thanks,
Thank you all.
Vinod. Thanks.
Bye.
Bye. Bye.